Hello guys. Today we're here to tell you about ADR, Alternative Dispute Resolution. These different ways are much more direct and usually less expensive than litigation. They also don't end relationships badly, like the typical litigation process.
The litigation process is something that is widely known in American society. From To Kill a Mockingbird, to My Cousin Vinny, to most recently, The People vs. O.J. Simpson, the American society is shown.
But what those movies and TV shows fail to mention is how expensive, long, and personal those experiences are. These shows normally have to do with intense criminal cases, but when it comes to civil cases, especially in business, it is of best interest to not ruin relationships with suppliers and buyers and to keep the prices of disputes low.
That is why there are multiple kinds of resolutions to use before litigation if the dispute carries on that long. There are three types of ADR, which is negotiating, mediation, and arbitration. There are things like med-arb that combine the two, and also these disputes have increasingly available to be dealt with online.
We'll keep it simple and only focus on the three traditional forms of ADR. We will start off with negotiation, then mediation, and finally arbitration. We choose to follow this order because this is the process of how disputes are dealt with, from the most casual to the most formal.
For negotiation, the goal is to have a meeting of the minds. This happens all the time, and normally people don't even realize that they are using a form of ADR.
Typically see negotiation used when settling business-to-business disputes. Negotiation is a method of alternative dispute resolution that retains power to resolve the disputes to the involved. No outside party is vested with authoritative decision-making power concerning the resolution of a dispute. Negotiation requires the parties to define the conflicts and agree to an outcome to resolve these conflicts. Often, this can take the form of a compromise.
Negotiation is typically considered the winning solution for both parties involved in settling disputes. Benefits of these specific ADR include speedy resolution, inexpensive nature, and voluntary participation. Disadvantages include no set rules and parties may bargain unfairly. In other words, the objective of negotiation is to come up with an agreement that benefits all parties involved. Most of the time, parties must give up something in order to negotiate. Giving up something usually allows for gains in other areas of the negotiation process. A simple example can be Company A and Company B want to merge, but must first agree on price, financing, and management changes.
Mediation is the second alternative dispute resolution we will touch upon. Mediation, like negotiation, parties in mediation do not vest authority to decide the dispute in a neutral third party. Instead, this authority remains with parties themselves, who are free to terminate mediation if they believe it is not working. Mediation seeks a common ground for the parties that are involved. It involves a mediator who would be considered a neutral, unbiased third party. Mediators talk face-to-face with parties usually in different rooms to establish a common ground. Benefits include few rules, parties control results, and a customized process. Drawbacks are mediator fees, no sanctions, or deadlines.
Finally, we'll explore the unknown seas of arbitration. This form of ADR is the most formal and is usually binding if it's court-ordered. Arbitration looks a lot like a court hearing with planned arguments and evidence. Arbitration commonly happens during disputes in business contracts. A lot of these contracts have pre-existing terms that if any dispute erupts between the supplier and buyer, they will solve the issue using arbitration rather than litigation.
For a party that is confident they'll win the case by having an ample amount of evidence and information compared to the opposing party. Arbitration is almost a sped-up, less formal version of litigation. This means the two dispute resolutions look alike, but in actuality, arbitration is way more flexible.
Arbitrators have the capability to split the baby, which is usually considered a bad thing, which allows both parties to win fractionally. The pros of arbitration are that it is in a sense a private form of litigation and also allows parties that are a stalemate to come up with a final answer that they cannot change. It is also less expensive and takes quicker than litigation. The cons are that it is more expensive and more timely than negotiation and mediation. Also, it is commonly said that it can be unfair because a part with more resources usually wins. It is also a dispute resolution that does not end as pretty as mediation and certainly as well as negotiation.
What we would like for you to take away from this video is that it's possible for you to come up with a resolution before resorting to litigation.
Litigation is a timely, expensive process that can really tarnish relationships, especially business relationships.
As time goes on, people will realize how easy it is to avoid litigation and all the money used in the process. We hope this acts as a good guideline to each kind of ADR and brought some awareness to these other methods. We urge all of you to research on your own time to save thousands of dollars.
Thank you for watching. I hope you guys enjoyed our video and learned a lot about ADR.